to paragraphs 1 to 3 as irrelevant as the steps taken by the first respondent is in accordance with the Public Election Regulations CI 127. My Lords, with the greatest respect, whether they are in accordance or not in accordance, indeed, my lords, the logic of the questions 1 to 3 should be obvious on the face of those questions. Questions 1 to 3 start from the practice before to for saying that these questions are irrelevant to determine what actually happened, which is what this case is about. And in paragraph 5, she proceeds to object to answer 4, 5, 6, 7, and 8. Now, my lord, 4 is how were results transmitted from the constituency collation center to the regional collation centers. My lord, I mean, this question can hardly be irrelevant to this petition, because this question about how results were transmitted is critical for the determination of the authenticity that she's claiming for the results that she declared.
Mr. Chikata, could you kindly point to the paragraph of your petition that this question is related to?
The paragraph that is related to is the paragraph of the first respondent's petition, as I indicated earlier. The answer.
Which paragraph?
The first respondent.
Which paragraph?
Paragraph 5, I referred to earlier. Paragraph 5, where she sets out, where the first respondent, not she this time, the first respondent, Electoral Commission, sets out the 4-stage procedure.
Thank you very much. Thank you very much.
And so my submission, the question how this collation was transmitted, or how the results from the collation center at the constituency were transmitted to the regional collation center, and how the results transmitted from regional collation were transmitted to the headquarters. Those questions 4 and 5 are clearly critical to what was actually done in this election, not just what is had to be done in general terms, but what was actually done. And Lords, we cannot see how questions 6, 7, and 8 we would like her to wait until you have given us leave to serve her, and then we can read her answer at that point. She is anticipating it in paragraph 6, and we are grateful for that anticipation, but that should await your Lordship's grant of leave, and the service on her, the service on the first respondent of the interrogatories. My lords, there are other responses in the remaining paragraphs. I only comment on the one suggestion that we are unnecessarily attempting to delay the trial. Nothing could be farther from the truth. And we actually take exception to that suggestion and that averment in the affidavit. We take strong exception, in fact, I may say, to that suggestion that we are attempting. The purpose of discovery, as I've indicated, is to limit the matters for trial. And if only she would just stick to answering those interrogatories, I think the processes of this trial would be expedited rather than to make facetious statements about our intentions. We are therefore respectfully asking that your Lordships grant us leave, and I believe that upon these interrogatories being filed, they can accelerate the processes for responses from the first respondent, and therefore for the further processes of this trial. That is all.
Yes, my lords. My lords, we are opposed to this application. Lords, we rely on all the depositions in our affidavit in opposition. Lords, with respect, the answers to the questions being sought are in the petitioner's own petition, the answer filed by the first respondent and also the answer filed by the second respondent. My lords, Regulation 44(9) of CI 127 sets out how the first respondent will declare results. And in it, questions being asked of us that where did the regional coalition center pop up from is all in the law. That is why we are saying that everything is in the law before this court. And those are the steps that the first respondent followed. My lords, my lords, with respect, Regulation 44 sub 9, the regional coalition officer shall, upon receipt of the presidential election coalition forms as set out in Form 9 of the schedule and the presidential election results summary sheet as set out in Form 10 of the schedule from the district electoral officer in the presence of the public and with not more than 2 counting agents appointed by the parties contesting or the polling agents of the party, if any, assemble and collate the presidential results from the constituencies as set out in Form 10 of the schedule. Fill the presidential regional results coalition form as set out in Form 11 of the schedule. Fill the presidential regional results summary sheet as set out in Form 12 of the schedule. Request the, so my lords, it is all set out. That is where what is done at the regional level. And my lords, we have pleaded in our answer that indeed the petitioner had signed 13 of those forms. My lords, we have also stated in our answer that where a party fails or refuses to sign on any of the forms at every stage of the process goes on. Yes, my lords. My lords, just a second.
That you are submitting before the court that your responsibility is stated in the law, as you rightly stated. Yeah. So, can you? I know, depending on the ruling of this court, you may have to answer or. But
my lords, regarding you are asking about question 4 and 5. Yes, my lords, as we have stated, I think somewhere in the answer, it's transmitted by fax. Now, my lords, we would also realize that the questions posed seek to introduce through the back door new facts which are not anywhere in the petition before this court. My lords, I wish to refer your lordships to the case of Nana Addo Dankwa Akufo-Addo versus John Dramani Mahama and the EC. Lords, is reported at page 61 of the special edition of the Supreme Court of Ghana Law Reports. My lords, I would draw the court's attention to page 71, and with your kind permission, let me read what the court, the Supreme Court, speaking through Adina JSC said. In the circumstances, we hold that the petitioners are sufficiently and well informed about the election results, which has enabled them to mount this petition on grounds of malpractices in 4,709 polling stations based on the contents of these duplicate documents in their possession. The affidavit in support of the application does not disclose any need for the inspection and making photocopies of original documents. Lord, I wish the court to apply this decision and hold that the matters for which the petitioner seeks interrogatories are well within his domain, and he was well armed with those before he filed the petition in this matter, and therefore he is bound by his pleadings in the petition and therefore cannot come through the back door and seek further information through these means. Lords, I would also wish to refer your lordships to the Metronunu case, Lords. Lords, it is Metronunu and others versus the Electoral Commission, 2007 to 2008, Supreme Court of Ghana Law Reports, 1250. Lords, I wish to draw the court's attention, with your kind permission, to the obiter dictum of Dateban JSC. It says, it should be noted in particular that Article 49.3 requires the announcement of the results of the voting at the polling stations before they are communicated to the returning officer. Such announcement has the effect of putting the results in the public domain. Observance of Article 47 means, in effect, that the Defendant Commission publishes at each polling station the results from that station. We do not therefore see the need to imply as a condition of the validity of the declaration of the election of the President-elect the added publication obligation that the plaintiffs have argued for in this case. If the election system operated by the defendant could not function without such a publication, we could have been persuaded to imply such a publication in order to make the system workable. So, my lords, the point we are making, the submission I'm making is that there are over 38,000 polling stations countrywide. The petitioner are appointed agents, at least 2, in each polling station. The results were counted, forms filled, his agents signed. If they refused to sign, he moved on to the constituency. They were collated. He had agents there. They signed. If they refused to sign, he moved on to the region and so on. And then the returning officer, the presidential returning officer, got all these sheets. The petitioner's own agents signed 13 of them. The second respondent's agent signed 14 of them. Some of the 12 other agents signed. There was no total signature on all the 16, but based on the law, the system continued. So, my lords, the information that they are seeking are well before the court in the pleadings, in the petition, in the answer. And therefore, it's our prayer that this application be refused.
Mr. Amenuvo,
yes, my lord.
My understanding of part of the submissions of the petitioner is that in 2013, during the 2013 election petition, an application was made for interlocutories by the then petitioner before this court. And the court granted it.
Yes, my lord.
The decision given by Badebe JSC at from page 54. And so this is a similar application for interrogatories, which is before us. So this is being used as precedent.
No.
So what do you say? Because counsel is entitled to rely on precedent and invite the court to follow precedent already set out.
My lords, distinguishable precedent. Distinguishable precedent. My lords, with respect, the 2013 situation is different. And mind you, my lords, interrogatories, grant or refusal, is discretionary. And it has to be based on the set of facts at every situation. It doesn't arise in this case. It doesn't. And that is why I said, yes, there is precedent, but precedent is distinguishable based on the facts and the processes that are before you in the pleadings, my lords.
So why are you saying that in this particular case it is not applicable? In
my
this
lords,
particular petition, why are you saying it is not applicable?
Beloved, because the answer he seeks are all in the document before the court. And then the law that they themselves have relied on, which we also rely on, they are there. I just read to you the steps. You are asking me that when did the original issue come up, etc. If you read the law, you see that it is in there.
Thank you.
Thank you very much, my lords.
My lords, I pray that I be permitted to make a few observations of law.
Are you making observations or you should be permitted to respond?
Submissions.
I think the application is basically directed at the first respondent. Because you will not be compelled
answer.
To answer any question.
Yes.
If I understood counsel for the petitioner,
Yes.
you are not under any obligation whatsoever to answer any of the questions serialized in the document annexed to the affidavit.
Yes, my lord, and it is true that no specific interrogatory has been directed to
Second respondent.
the second respondent. However, we are an interested party in this matter, and if we can, on legal issues, we think we should be permitted to do so.
Yeah, Mr. Akutan. If, as you rightly said, if it's a legal issue, if it's a question of law, we can hear you, because seriously you did not file any affidavit in position regarding.
My lord, I think the first point to make is that interrogatories must relate to matters in contention between the parties.